Good afternoon. This is Anita Casey. I'm speaking to everyone from the State Bar Center. We are doing one of our every other month webinars. This is not in the COVID-19 category, which we have done quite a few in. This is a real legitimate non-COVID webinar, and it's going to be a phenomenal webinar. It's in law office management. I'm going to be listening to every word these gentlemen say because they are going to be talking about technological competency, best practices, and how to work the State Bar database. So I think everyone's going to learn a lot today, including me. This webinar is worth 3 credits in law office management. That is, people think you have to have ethics. You do not. It's ethics, law office management, elimination of bias, or attorney wellness. So if you need 3 hours in what some people refer to as ethics, you are getting it today. These credits can be applied either to the 2018-20 or the 2020-22 reporting period. At the end of the webinar, Mike Mellace, who will be our 3rd speaker, will send an email to everyone who is registered. You need to accept that email and designate whether you want it on 1820 or 2022 for your 3 credits. Before I introduce the speakers, I want to let you know how we're going to handle questions. I will be monitoring your questions through my email address. Please send any question you have for the speaker in a question format to my email, which is caseyA@wvbar.org. Again, that is caseyA@wvbar.org. All of our speakers have agreed that when the question is presented, I will ask them. So this will be very informal. So you don't have to wait till the end to present your question. Just present it as it comes up, and I will ask it as soon as the speaker takes a break. Before I turn it over to Mr. Embry, I'm going to introduce all the speakers very, very briefly. Steve Embry is I'm very happy to say, a member of the West Virginia State Bar. Even though he has his principal place of business in Louisville, Kentucky, he comes and sees me and our bar quite frequently. He is a frequent speaker, blogger, and a writer. His blog is Tech Law Crossroads, and it's dedicated to dealing with technology, the law, and the practice of law. He is part of the Leadership Council of the American Bar Association's Law Practice Division, and he is a national litigator and advisor primarily in the areas of mass tort, business and consumer class action, privacy, and data breach arenas. It scares the hell out of me to think about that. Our second speaker is Burney. Brett is the principal of Burney Consultants. Again, he is formidable in the legal and technology fields, deals a lot with electronic discovery. Those of you who are in the counties that have electronic discovery, he will be very helpful. But for those of you who do not yet have the e-filing, I think he's going to be very helpful to provide information with regard to e-filing and how to do electronic discovery. He works with litigation teams in building document databases, counseling on electronic discovery issues, and how to handle those electronic matters at trial. Our final speaker, Mike Mellace, has been with the State Bar since 2012. He has a bachelor's from Marshall in Management Information Systems and a master's from Marshall in Technology Management. He is an integral part of the State Bar. He works with every one of the staff members here. He keeps us going. He literally has played a critical role in creating and updating websites, all of our databases, and he handles the smaller matters like phone systems and hardware, which we can't do without. So without anything further, I'm going to turn the presentations over to Steve Embry.
Good afternoon, everyone. It's nice to be talking to all of you in West Virginia. I practiced law there for a few years and enjoyed my time here. there. The way we're going to proceed this afternoon is each of us have some remarks to give, a presentation to give, although it's going to be rather interactive between the three of us and hopefully all of you. We really want to talk about issues that are important to you and important to your practice. And the only way we can do that is to hear from you. So if you have questions, please feel free to sing out and follow the instructions that Anita so articulately gave you. So let me start asking a question: why technology is important to us as lawyers, both from an ethical standpoint and a practical standpoint. So let's suppose you came into work this morning and opened up your email and you saw what appeared to be an email from Anita Casey. The email address appears to be accurate. It's addressed this time to me, and the subject is West Virginia Bar Complaint. Now, I don't know about all of you, but there's probably nothing that would scare me more than to start my week out with an email like this in my inbox. And so my first reaction would be to read this carefully, quickly, because I'm now in full frightened mode. And again, being a good lawyer, my first reaction would be go to the bottom, and I see a link there and I want to know what the complaint is, and I would click on it. And if I did, this is what I might find. An email telling me that unless I was ready to pay some amount of Bitcoins, $300 worth, all of my files would be taken from me and removed forever. And so that puts us, any of us, in a difficult spot. And this actually was a scam that was run out of the state of Florida and got many lawyers to click on and see this. So this is an example of why technology is important to us as lawyers. So let's talk a little bit about the reasons to care about this. Some personal background: I've practiced law for 30 years or so, still practice law, but I'm also big into technology. Now, I'm not a computer person, I'm not a geek, I don't know how to code, but like many of you guys, I probably spent a lot of years avoiding technology like the plague. I was one of those people that kind of proudly professed that I wasn't technologically savvy. I didn't know anything about these computers. It wasn't important, blah, blah, blah. Then as I began to have a family, I began to get very busy at work. I was looking for ways to try to get more work done at a quicker pace, to automate things and to do things in a more efficient manner. And that led me, of course, to technology. And it became a lifelong interest at that point, both for that reason and a number of others. Ultimately, it led me to start a blog on the subject and learn more about it. I think the first place we go to ask ourselves about technology is how proficient do each of us feel? Do we really feel like we're using technology to our advantage? Do we feel like we're lost when it comes to technology? Or do we feel like, well, we have other people in our office that can take care of technology and we don't really need to concern ourselves with it because we just rely upon them? The question we should really be asking ourselves, though, is do we keep abreast of the risks and benefits of technology that are relevant to our practice? That's the duty that most states have imposed. It's a discretionary duty in most states, but as we'll find in a minute, in West Virginia at least, it is a mandatory duty. As lawyers, as West Virginia lawyers, we must keep abreast of the risks and benefits of technology that are important to or relevant to our practice. Now, I realize, of course, that as lawyers, we have some things that work against us when it comes to experimenting with technology and learning about technology. We're skeptical by training. All of us know that it's our job to look for problems, and that that sometimes works against us when we want to learn about technology. We're risk adverse. We don't like to experiment or try new things. We're trained to look toward the past. We live in a world of precedence and tradition, and that frequently works against learning and using and being innovative with technology. Maybe more important, as lawyers, most of us are just downright independent. 69% of law firm leaders say that most of their partners resist any efforts to change, and 56% say their partners are just blissfully ignorant of how they could do things differently. And let's face it, for many of us, our business model is the billable hour. How do we maximize profit? We bill more hours. But to use technology, we have to spend not only money, but also time to be trained. We have to work with the technology. We have to understand it. We have to practice it. And that's not billable time. So for many of us, none of this comes naturally. It's not easy for us to become technologically proficient as the rules might require. We have to work at it. Now, whenever I give this presentation, somebody always asks, well, does this mean I have to know how to code? That's really complicated. I don't know if anybody here does know how to code. I don't know how to code. And often there's a dispute amongst us that write in this area, and Brett and I have had this discussion before, should lawyers know how to code? I like to think of it in terms of maybe an automobile, for example. Now this is a nice, beautiful, all-electric Tesla, beautiful, wonderful car. It can go from about 0 to 60 miles an hour in about 3 seconds. It can go 300 miles on a charge, and it more or less drives itself. Now, if you were to buy one of these, what you would do is you would pull out the owner's manual, you'd learn about the features, you'd learn about how to drive it, where the controls were, how to operate the entertainment center. You might learn about the self-driving features, you read about the maintenance schedule, and you probably take it out for a spin in the parking lot at first, make sure you knew where everything was and how it worked. But you wouldn't necessarily know engineering-wise how all this worked for this brand new Tesla or for any model automobile. What you would know is the features and the benefits that are relevant to your driving style and your particular circumstances. And email and the internet is probably another example we can think of. We all use the internet every day. We send emails every day. Most of us, and myself included, couldn't explain to anybody in this seminar how all that it works from an engineering perspective. But I don't need to know that. All I need to know is how to use it. And so when we talk about technological competencies, that's what we're basically talking about. How to use the features and the benefits of technology. So if we go back to our first question, why is technology important to us as lawyers? First is its pervasiveness today. And this is a good quote from former Justice Kennedy of the Supreme Court, talking about the dimensions and vast potential of technology on any sorts of things, all sorts of things. So I like to think about the reasons to be technologically proficient in two ways. One is the carrot and one is the stick. Let's talk about the stick, those pesky things called ethics. We basically, when we talk about ethical duties for lawyers, are basically 4 rules in play. Number 1 is the competency rule, Rule 1.1. We have a duty to competently represent our clients. And we have to ask ourselves, what does that mean in terms of technology? Secondly, Model Rule 1.6 is the confidentiality rule, and it talks about our duty to protect client competences, which becomes important when we use technology, things like email or cloud computing. Number three, we have a duty to work efficiently and bill for the efficient use of our time. This is Rule 1.5, and more technology is beginning to impact that, how we practice, what we can do, and what are our requirements or obligations to our clients. And finally, we have some supervisory responsibilities. Model Rule 5.1 and 5.3, which talk about how to appropriately supervise not only lawyers, but people who are not lawyers that may work in our offices, or vendors for that matter. So to go back just a little bit in time and kind of put this in perspective, in 2009, the American Bar Association created the Ethics 2020 Commission. And one of the things that this commission was charged with doing was to look at how technology might affect the model rules. And after studying the issue, this is what the ABA said. Technology has irrevocably changed and continues to alter the practice of law in fundamental ways. And lawyers must understand technology in order to provide clients with the competent and cost-effective services that they expect. This gets again to the competency obligations and also to our duty to bill effectively. So this is, pretty strong language when you think about it in terms of if you were to substitute technology for something else, like the rules of evidence for those of us that are litigators, or God forbid for me, the Uniform Commercial Code, because I'm not a commercial lawyer. But when you think about these sort of comments and obligations in that light, sure, if the rules of evidence irrevocably change and alter the practice of law, yes, we need to learn about it and do it. So what did the ABA do after the 2020 Commission? They adopted Comment 8 to Model Rule 1.1. And Comment 8 talks about what needs to be done as lawyers. And it says to maintain the requisite knowledge and skill to comply with Rule 1.1, a lawyer should, this is the model language, should keep abreast of the changes in the law and practice, including, and this is the important part, the benefits and risks associated with relevant technology. There are basically three simple concepts here. First is should. In West Virginia, it's must, keep abreast. Secondly, it's the risks and the benefits. And third, it's the relevant technology. And I want to focus on the relevant technology because this is important. To some of us, there are pieces of technology that just aren't relevant to our practice. Just as the rules of evidence are not relevant to a merger and acquisition lawyer, or for me, the Uniform Commercial Code, it's not particularly relevant to my practice. We don't have any duty from a technological competency standpoint to be familiar with those pieces of technology that we don't use and we don't need to use to represent our clients. To go back to our car analogy, for example, if I'm not ever going to use the self-park feature on my car, then there's really no need to learn about it, and I wouldn't learn about it. I'd leave it alone. Now, let's then think about, look at what West Virginia says. West Virginia's Comment 8, again, is a little bit different because it is the one state in the United States that says a lawyer must keep abreast of the changes in the law and practice, including the benefits and risks. That sounds strong, although I think when you consider what has happened since Comment 8, Model Comment 8 came out, this may be a distinction without a difference because, for one reason, at this point, 38 states in the United States have adopted Model Rule or Model Comment 8. A number of others have go back here. A number of others have adopted similar kinds of rules relating to technological competency. And in fact, to stress the importance of technological competency, the American Bar Association in February 2017 came out with some guidelines on what kind of continuing legal education requirements there might be and ability to obtain credit for CLE relating to technology. And they gave us some good definitions here that I think are helpful in sort of understanding the ethical requirements of technological competency. Technological programming means programming that's designed for lawyers, not for IT people necessarily, or coders or anything of that. And it's designed to provide an education on the safe and effective ways to use technology, again, focusing on the practice of a particular lawyer and what may be relevant to that lawyer in representing his or her clients. The ABA gave some examples of good programming, such as that would satisfy this definition, such as the ability to communicate, conduct research, ensure adequate cybersecurity, manage a law office practice and legal matters, all of which is kind of a good roadmap to understand sort of the parameters of Comment 8 and our technological ethical responsibilities. And as I said, a number of other states have also adopted similar language. 2 states, at least at this point, Florida and North Carolina, have actually require lawyers to have a CLE specifically as part of their CLE overall requirements, specific CLE in technology, Florida and North Carolina. And more recently, the New York State Bar Association began looking at doing much the same thing. So more and more states are recognizing this, and certainly the bend, the arc, is toward the idea that lawyers need to be technologically proficient. A lot of the opinions that talk about technological proficiency stem from e-discovery kind of matters. And there's one that is particularly important. It came out of California a few years ago. It's Formal Opinion 2015-193. And while this does deal with e-discovery, I think it's got some important language in it when you think about your obligation for technological competency. First, the opinion talks about almost every case today involves e-discovery, and I would suggest that not only almost every case, but really every case does, because you need to assess in the beginning when you first get a file in a case whether it's going to involve e-discovery. Secondly, one of the things that the opinion pointed out is that the lack of technical knowledge could result in you being considered ethically incompetent, even if, and this is of course caught my attention, even if you are a highly experienced practitioner. Lack of technical knowledge in handling an e-discovery matter may render an attorney ethically incompetent. That's the actual language of the opinion. And it also recognized that while as lawyers we can essentially engage others to help us with e-discovery matters, either through vendors or other people in our office, which is true of any technological program that we want to run, we still have the overall supervisory responsibility. The lawyer is still in every way the captain of the ship. Just like when a brief goes out with your name on it that perhaps an associate was the primary author, you're still have the overall responsibility for what is in that brief, which gets us to rules 5.1 and 5.3. 5.1 deals with the responsibilities of a supervisory lawyer for other lawyers, and it requires that a lawyer undertake reasonable efforts to make sure the lawyers that he or she is supervising fulfill their own ethical responsibilities. And in this subject matter here is the ethical responsibility to be cognizant of the risks and benefits of relevant technology. Rule 5.3, on the other hand, talks about our ethical responsibility to people that are not lawyers, vendors, for example, that we use. And it says that as lawyers, we have to make reasonable efforts to make sure that those people are what they are doing is also in compliance with ethical obligations. So let me stop here just for a minute because one of our other panelists here today is an expert on e-discovery. And Brett, you're familiar, I know, with the California opinion. And so we'll give us a couple of minutes of your thoughts about how this opinion may relate to our duties as lawyers to be technologically competent.
Yeah, thanks, Stephen. Hopefully you can hear me okay. And wow, you're doing a fantastic job going through all of the basics here on the technology competence and just kind of having an awareness of it. I'm going to underscore quickly your first point, Stephen, that every litigation matter today involves e-discovery. Now, the reason I say that is because you may choose to print something out in a piece of paper, but where does that printout come from? Virtually everything you're going to touch today, anything that's involved, at least certainly from even a civil litigation, but I find this across domestic issues, construction litigation, criminal anything that involves today, you are dealing with electronic information. Now, you may choose to convert it to a PDF, or you may choose to print it out, but every matter today involves e-discovery. We just may not deal with it in its electronic or digital form, but it's something that you must absolutely be aware of and be cognizant of going forward. And now, kind of like what you said a couple of times already, Stephen, I get pushback on this from a lot of folks that say, well, we know that's true in the big cities, right? But you don't know where I practice. We don't really deal with a lot of the electronic stuff. But I'm going to push back today because you do. The fact of the matter, you're dealing with text messages, you're dealing with social media, you're dealing with electronic email is the first and foremost thing that we still look at. And then the last thing, Stephen, on this California ethics opinion, it is the only one of its kind. It's amazing to me that I haven't seen more states adopt this, but California is kind of one of those renegades out there that do it. But pretty much it has been cited across the country in several states because you have three options basically when you are dealing with e-discovery. Number one, become competent in it, right? We all have that capacity. We can become competent about something just by learning about it. That's why as legal professionals, we can learn to represent somebody on a case maybe we've never dealt with. But that's your first option. Learn it and be comfortable with it. Number two, if you're not comfortable with it, then find somebody that knows what they're doing and you connect with them, right? That kind of follows in line with what you were just saying, Stephen, is that you are basically overseeing what they're doing. Find somebody like a consultant, for example, or a service provider, somebody that can help you. Or number three, your third option is decline the representation, right? I mean, that's what the opinion says. You have those three options. So thanks, Stephen.
Yeah, and I would say that again, point out that no matter what, if you get somebody else to do it, you still have some supervisory responsibilities. It's not as if you can wash your hands of it.
Right.
That's unfortunately that seems to be the attitude of a lot of lawyers. And I'd also point out that particularly for litigators, you can't lose sight of the 2015 amendments to the Federal Rules of Civil Procedure relating to discovery, which require you to come up with some e-discovery plans that you typically negotiate with the other side. And I have seen and experienced, quite honestly, an ability to obtain a litigatory advantage by being more familiar with e-discovery principles and concepts than the lawyer on the other side. And so again, to competently represent your clients, yet another reason to be proficient with technology. Incidentally, the California opinion also talks about duty to maintain client confidences under Model Rule 1.6, and hopefully we can get to those in just a moment. I want to talk a little bit more about email communications and cloud computing, because that frequently comes up here. Several years ago, the ABA came out with Opinion 437, which basically recognized our ability to use email communications and satisfy our ethical responsibilities as long as we undertook reasonable efforts to prevent inadvertent or unauthorized access, which basically freed us up to use emails, including emails to and from our client, without having to worry so much about the engineering or technical requirements. But recently, the ABA came out with another opinion on this, formal opinion 477, basically recognizing that we have our changing technological world requires some reflection, really. And what they basically said is there is no longer a hard or fast rule relating to how to maintain client confidences when it comes to emails. Now, you know, we basically, that's like saying it depends, right? And you know, I would hate to think how many times I've answered a client inquiry with the words "it depends," and you know, that's a favorite phrase of ours, but it's not so much fun when it's on the other foot. Now, the opinion talks about 4 things that may influence the "it depends" answer. First, it recognizes that different types of communication by email require different levels of protection. Think about Edward Snowden, for example. Now, you might think Edward Snowden is a criminal or a traitor. You might think he's a hero. But ignoring that for a minute, if you were to represent Edward Snowden, if you were his lawyer, you would have a lengthy discussion with him about maintaining the confidentiality of emails, and it would go beyond merely just send emails back and forth in the typical way. This is what the ABA 477 opinion is sort of getting at, and it recognizes that there are a number of factors that you need to sort of consider when you're thinking about the level of protection for emails. The sensitivity of the information, for example. The likelihood of potential disclosure, the cost of employing safeguards, the difficulty of implementing those safeguards, and the extent to which, and I think this is important, the safeguards might adversely affect your ability to represent your clients, i.e., is it too complicated, is it too difficult, that's going to interfere with your ability to competently and capably represent the clients. So the ABA recognizes, again, that there are a number of situations that would require greater consideration of the confidentiality. And the important thing here is the ABA goes on to say that a lawyer has some duty to understand these threats and determine if the client's matter is at a higher risk for cyber intrusion, and most importantly, have a discussion with the client at the beginning of the relationship about the levels of security that might be necessary. And so in order to do that, you of course have to have some knowledge of what's at risk, how the technology works, the risks and the benefits of it in order to have that kind of discussion. And this includes not only security in transit, but security at rest. We frequently don't think so much about security at rest, but it's important. I mean, I know a lot of us use these little flash drives and carry them around. I dare say if I took a poll of everybody that's participating here today, how many of us would have lost one of those? I would count myself in. But we have to think about that kind of security at rest. And again, we also have to think about it in terms of where we are today with the pandemic and what's going on with how we now communicate with clients. Recently, the Pennsylvania Bar Association came out with a formal opinion 2020-300, which talked about working remotely and the potential security concerns and confidentiality concerns. whether encryption would be required, what kind of firewalls need to be put in place, the need to make sure everybody working remotely has a virtual private network or VPN, the use of two-factor authentications. And we have to think about this in terms of lawyers and staff that work for us, right? I mean, many of our younger lawyers right out of law school may have roommates. And we need to be sure that those lawyers, if they're working remotely, are taking adequate protections to make sure the client confidences are preserved. Another thing this opinion talks about is cloud computing. I often get a lot of questions about this, and I know Brett, you do as well, and Mike also probably does, whether it's safe and secure. And I think most of us would tell you that depending on the vendor and the nature of the cloud security, it's probably more secure than storing files on premises. But again, the formal opinion here talks about selecting a cloud vendor and our duty as lawyers to investigate not only the cloud vendors we may use, but any other outsourced vendors that we use in a technological fashion. We need to look at things like their qualifications, their competence, their diligence, their reputation, their longevity. We need to look at the contractual protections that may be in place. Who owns the data? How the data could be returned. We need to look at reference checks. We need to look at security policies. So again, we have a number of duties that require us to be cognizant of risks and benefits of technology when it comes to selecting vendors and making sure that we can comply with our duty to maintain client competencies and represent clients. And again, we have this formal opinion recognizes our supervisory responsibility to lawyers and vendors, not to be a broken record, to use an analog analogy, but how can you supervise people if you don't have some inkling of what it is you're supervising them for? Now, there are a couple of West Virginia opinions that you probably should be aware of. The first is 2015-2. This deals with social media and attorneys, and basically what it provides is that to comply with comment 8, you must have an understanding of how social media and social networking websites function, and be equipped to advise your clients about various issues they may encounter as a result of their using social media. And I think many of us have used this both in a defensive way, but also to help our own clients in looking at another party's public web postings, never their private public web posting, that would be unethical, but what they posted publicly. But we have a duty to tell our clients about the confidentiality impacts and how posting on social media may impact their matter. The second opinion is 2012-01. This talks about the use of electronic media for file storage, such as cloud storage. First, it says that you may want to advise your client of the method of file storage in your retainer agreement or engagement letter. Again, this requires some level of knowledge about tech and file storage. It also provides that various forms of storage are proper, but you have to use due diligence to protect the client's file, the confidentiality, the accessibility, and the integrity. So again, this gets back to many of the things mentioned not only in ABA Opinion 477, but also the California opinion, which talks about security of data and control of data and safeguarding of privilege. Again, this leads us to probably a good consideration of security just in general. So when you look at many law firms, that the old adage is there are two types of law firms: those that have had a data breach and those that have had a data breach but don't know it. You look at the data from the ABA, you see that many of the breaches are in firms of between 10 and 49 attorneys, and also 500 or more attorneys. But more and more law firms are being subjected to data breaches. Most of us have heard of the Panama Papers scandal, where a number of client records were obtained and posted publicly. It was quite embarrassing. Or the impact of the NetPetya cyber intrusion on firms like DLA Piper. Paid some 15 hours of IT overtime to get back up and running. Lord only knows how many billable hours were lost as a result of that. So, you know, the security angle of this is important. You need to think about things like scams and making sure your staff is adequately trained to recognize them, just as this email I showed you at the beginning. You need to think about things like strong passwords and password managers, two-factor authentication, all those sorts of things. And I have, I'm running a little short of time here, so let me skip over this video of Edwin Snowden talking to John Oliver and talk about a recent opinion of the ABA that talks about what you need to do if you in fact have a data breach. And these data breaches and gaps in our training in cybersecurity happen all the time. Many of you may have heard about the Wilmer Cutler debacle, in which a younger lawyer was discussing a pending but not yet public a criminal investigation, and he was sending an email to a number of client representatives and also partners in his firm, and he began typing a name of one of them, and the technology did an autocomplete of the email address, and it just so happened that it auto-completed it with a reporter at the Wall Street Journal, and which immediately revealed the criminal investigation. It also Jones Day recently also had a significant debacle when a lawyer tried to redact a number of files, simply highlighting a portion in black in a document. And of course, as most of you know, that's very easily to gain access to what's been highlighted by just taking it off. And so all the redactions come through. But let's talk about these 5 things briefly that opinion 483 of the ABA came up with about our obligations and duties if there is a breach, because I think it's a good summary of most of the opinions we've been talking about. First, of course, we have a duty to protect our client confidences and information so that there is not a breach. And this doesn't change just because they are in a digital format. Secondly, we have the ongoing duty to monitor our systems to make sure our digital information is safeguarded, and to supervise others that have access to that information to make sure that they take steps, that they don't fall victim to scams and other things that lead to a breach. Next, we have the duty to stop and mitigate any cyber intrusion that we discover. And this would include having an incident response plan in order to protect our clients if we have a breach. And of course, we have the duty to notify, or may have the duty to notify. Under Rule 1.4, you have that duty to tell a client of something that has happened if that thing that has happened will affect the client's ability to make informed decisions. So the issue really in part depends on whether the disclosed information is confidential, whether the disclosure affects your ability to represent the client, and whether the disclosure will affect the client's ability to make informed decisions. Those are the considerations for notifying client. Many clients I know take the position, and I've heard many of them say, we don't care about any of that. We expect and anticipate our lawyers to tell us if their systems have been breached. And you know, that's a tough thing to do. When you think about Wilmer Cutler, when you think about Jones Day, I'm sure that the partner in charge of any of those matters, the last thing he or she wanted to do was to call their client and tell them that there'd been a disclosure of a confidence because they were not able to adequately control or train their people. And finally, beyond, we have the duty to restore the system, get it back up and running so that we can continue to represent our clients. One last point, again, the 5 things: prevent, monitor, stop, and mitigate, restore, and notify. The last thing I wanted to mention before my time is up is the ability to be aware and bill in work in a cost-effective manner. There's several things at play here, but generally speaking, you're expected to work in a way that's normally accepted within the profession, and to use the tools that are normally expected to be used by a legal professional. And increasingly, that norm is bending toward more efficient use of technology. I've got just a second here. I want to turn to Anita and maybe to Mike as sort of people on the ground and in the trenches in West Virginia, and ask them to relay the experiences that they've had with respect to West Virginia and Model Rule 8, and how they and their offices there may be interpreting that.
Steve and I talked about this earlier. We do not obviously maintain the ethics. That's the Office of Disciplinary Counsel. But in our regional meetings, I have heard Rachel Fletcher Cipoletti on multiple occasions say that if you cannot handle technology, you are not competent to practice law. That is the position that the Office of Disciplinary Counsel has taken consistently since the model rule came out. Whether they are proceeding against individuals, whether they've had anyone who has been reported for not being able to deal with technology, I do not know that. I do know that here at the State Bar Center, Mike and I have been very, very adamant about taking down our paper processing. For years, they used paper processing. We gradually worked the paper out. I believe it's probably about 98% gone now. The Supreme Court, when our new rules came out in January, put higher penalties, I'll call them, on people who use paper products. So the court is supporting the use of technology in trying to get away from paper processing. Mike will talk later on about the e-filing, and some of you have experienced it, some of you still get to experience it, but e-filing is going to be taken over. It's already taken over in a number of counties. So technology is definitely, it's going to be here. If you don't know how to use it, you're going to have to learn to use it very, very quickly.
I think having the ability to find somebody that that you trust, that can do that for you and help you practice law from a secure technology environment is becoming a more important thing. And I think the next presentation is going to kind of get into that, where he's going to talk about mobile ethics. Some of the stuff that I've heard him talk about, I think it's highly important. So,
well, thanks, Anita and Mike. I appreciate that, and I enjoyed speaking with you. I don't know, Anita, if you want to take a break, but before we do that, I will throw a wild question over to Brett, because I know this is something that he's thought about. And the question really is, in the time of the pandemic here, what has he seen, what has he experienced with respect to lawyers and their need to effectively use various forms of technology, and what changes there may be occurring both with client communications, with the court system, and with other lawyers. And with that, I'll stop and either turn it over to Brett or let everyone take a break. Anita, I can't recall what your preference was.
I think we're going to go ahead and take a 10-minute break. Those of you who are on, please stay on. When we come back, we will get Brett to answer your question first of all, and then proceed with his presentation. So everybody, we'll be back on in 10 minutes.
Yeah, I think they did take a break.
With Kim. Yes, nurse practitioner. This is Anita Joyce Lauterbach's daughter. I wanted to ask Kim something about the mother.
We are going to start in 1 minute. We're turning the screen back over to Brett Burney, and as soon as he gets his displays up, we're going to turn it over to him to get started. Brett, you ready?
Okay. Yeah, I'm getting ready to pull it up right now. All right. How does that look? You can confirm you can see that okay.
We are good.
Excellent. All right. You just tell me when you are ready for me to go.
We've got about 40 seconds left.
Okay.
Anybody is finishing up a phone call or a restroom, we're going to turn it over to him in 40 seconds.
Excellent. And I'll just encourage everyone again quickly, Anita, that if anyone has questions, they can email it to you, right? You put your
Yes.
email address in the chat box there.
Yes, sir.
More
I'll
than
make sure
happy
Mike
to
gets
take.
it in there.
Good, good. More than happy to take questions from folks either during the presentation or right after. Always like to make sure that the audience is that you're getting the information that you're here to get, right? So the best way you can do that is by asking some questions. So we welcome that.
All right, Brett, it's all yours.
Okay. Well, thank you, Anita and Mike and Stephen and everybody for joining today. I know, wow, some weird times that we have going on, but I've frankly have really, truly enjoyed doing a lot of these presentations remotely and virtually. Although I have to say, I have had the honor and the privilege of going to Morgantown for, I think, the past maybe 8 or 9 years, when the West Virginia CLE sessions would invite me to come down there. And I always was very fond of going because it is, as I go around the country and give a lot of CLE presentations around the country, West Virginia is the only place that I would go where I had to be finished at 11:01 in the law school there so that everybody could get to the football game on time. It's the only CLE that I've ever had to speak at where it had to be done because of a football game. And obviously some of you that have been there, this is right on top of that hill, right, where the law school is, and taking a picture there of the sea of yellow down there. And I typically stay just for a little bit so I could hear, country roads. Anyway, it's a great time. So it's great to be with all of you here. And I think I even recognize a few of the names that I've had the privilege of meeting over the years that are in today's attendance. So I'm here to talk about specifically a lot of the things that Stephen was talking about, but specifically the mobile capacity or the aspect. So to do that, I want to just share with you a quick little story. This is a picture of Wildwater Kingdom. As you can see, this is Northeast Ohio's premier water park. I'm based in Cleveland, Ohio. Now, a few years ago, my family and I went to Wildwater Kingdom. It was toward the end of the summer. It was nice. We spent most of the afternoon there. It was lovely, but before we left, and it was about dusk time, we just wanted to do one more water slide before we left. And in fact, here's the picture. That orange water slide there in the middle was the one that we all decided, okay, we're gonna run and do this before we leave the park that day. So we had our bag with all of our towels, and we set it on a chair fairly close to this slide because we were just going to run up there, do the slide together, and come back. It was going to be great, a nice ending to the day. And we did this. It was wonderful. We go back to the chair to pick up our bag of our towels, and my wife reaches into the pocket inside to retrieve her phone, and it wasn't there. My money clip that I also had there wasn't there. Her phone wasn't there, and I think I had my driver's license that was there as well. Now, some of you may have been in this circumstance before, maybe not at Wildwater Kingdom, but you kind of get that pit in your stomach, right? Wait a minute, I know I put the iPhone here, and it's not there. Now, while everybody typically has that pit in their stomach, this kind of shows you where I come from a little bit on the techie nerd scale, that I got a little flutter of excitement because I knew that we had the ability to basically go and track that phone. So we actually ran over to the offices of Wildwater Kingdom, and the poor young lady there behind the counter would kind of looked at me, as I tried to explain to her that somebody stole my wife's iPhone, and I want to jump on a computer to be able to track it and see if the phone has left the water park before we left, right? Because if it hasn't left the water park, then theoretically a security agent could go and try to find it. Well, the computers that they had behind the desk there didn't allow them to get onto certain websites because I was going to sign on to iCloud.com. But another employee had an iPhone, and he was very kind to offer it to me and say, you can log in with your wife's iCloud account and you can track the phone. Well, I did that. I couldn't find the phone. It was obviously had been turned off at that point. Now, my wife doesn't typically listen to me like a lot of lawyers that I talk to, and she didn't have a passcode set on the phone, which is one of the first things we're going to talk about in just a moment that you should do for your phone today. But because I was able to log onto her iCloud account on this employee's phone, I said, if the phone comes back online, I want to apply this passcode to the phone, right? Because then that means if somebody had the phone and they were trying to access it, they couldn't be able to because it would have a passcode that was logged on. Now, some of you already know that there is a service with Apple iPhones called Find My iPhone, or today they just call it Find My because it allows you to track your little earbuds, your Apple Watch, your iPad, your Mac, your iPhone. And this is what I was accessing to see if I could try to find the phone. Well, we ended up filing a police report, and they were like, well, good luck. Hopefully we'll be able to find it. And we went home then at that point. Now, as soon as we got home, again, this shows my little tech nerd scale here. I immediately went to a laptop at the house, and I logged on to iCloud.com. Now, you can see at the top here that my wife called her phone the mobile mommy. And I don't know if you can see, let me see, hopefully you can see my cursor here. Here is Geauga Lake over here in the corner. I'll see if I can zoom in. Hopefully you can see that. And this is Wildwater Kingdom right here on the southern end of Geauga Lake. Now the phone wasn't there, but if you notice, when I jumped on iCloud.com, the phone was found in this parking lot. And this white building right here, if you can see that white building, happens to be the local Walmart. And it turns out that the phone was able to be tracked at that local Walmart because the thief had traveled, unfortunately, with her children to this Walmart and racked up about $1,600 on the credit cards that she had also taken from us out of that bag. Now, I saw the phone was pinged there 27 minutes ago, as you could see, but then I lost track of it. I couldn't find it until the phone showed up in a Dunkin' Donuts parking lot. And when I saw that, and it wasn't moving anywhere, like it was stationary there, I immediately jumped into the phone with my phone, into the car with my phone, and I drove down to Solon, Ohio, just a few minutes away, and found the phone in the Solon parking lot of the Dunkin' Donuts. So meet Lisa Camiolo. This is the lady, unfortunately, that had taken my wife's iPhone. And she had been stopped with her 3 children, who were about teenagers at the time, and by the Solon Police Department. And they found, of course, not just my wife's iPhone, but several other phones in there as well in the Dunkin' Donuts parking lot. And I walked up to this police cruiser that on the hood of this police cruiser, they had several of these iPhones there. And I was able to point to the one of my wife's. I immediately picked it up, and the police officer there was, well, this one was locked. We couldn't get in. But before he could even finish his sentence, I was able to unlock the phone because why? I had put that passcode on the phone before we had left Wildwater Kingdom. And I was able to recover that phone along with all my other personal property that Ms. Camiolo had taken that day. Now, why am I going through this story? Some of you probably have a very similar story or something very similar that you could share where you have successfully used a service like the Find My iPhone service. The point that I always make to everybody is to emphasize the fact that it is going to happen to you. if it hasn't already happened. The question is when it's going to happen to you, not if. It will happen to you. And the point is that you need to be prepared and ready for this, because it's not a question of if it's going to happen. It will happen to you at some point. Nearly 100% of you are using some kind of a mobile device today to communicate with your clients, to access your information, to check your email, to surf the internet. It's almost unheard of that a legal professional today would not have some kind of a mobile device. And our good friend down in New Orleans, Jeff Richardson, runs the iPhone JD blog. You can see that the vast amount of you on this call today are using an iPhone. If you're not using an iPhone, probably a good chance you're using an Android device. And then there may be a couple of you that are just holding on to that BlackBerry. God bless it. And hopefully you can keep on going with that. But you're probably going to be changing to an iPhone or an Android. Now, I remember the day that I first saw my mobile device. In fact, it was on a movie. Sergeant Murtaugh in Lethal Weapon, right? You remember that movie, Lethal Weapon? I remember he pulled over on the top of an LA overpass, and he pulled out this little briefcase of his car, and he dialed the number on this phone, and he called Sergeant Riggs, right? Mel Gibson, on this phone. And it just blew my mind when I saw this. How in the world can somebody have a phone in their car? Well, of course, that's a little bit of a briefcase he was carrying, but all of us probably on the call remember the days of the brick phones, the flip phones, the foldable phones, the candy bar phones. We even remember those days where we had the big BlackBerries. I called them slices of bread that we would hold up to our head and talk on. Well, today though, this is what we have. We have these beautiful gleaming slabs of glass in our hands, right? That we can do so much on today. And the one thing I want you to take away from this moment here is while we typically call these devices mobile phones, we think of them as a phone first, right? That can also make some birds angry or crush some candy, right? We think of them as phones that can do some other things. But I just want you to start to think about how many things that your mobile phone today has replaced in your life. Maybe you don't have the time to sit and do this, but I do because I'm the nerd here. But I just started to make a list of all the things that my phone has replaced. It is the first place I check for my email, my calendar, for my task list. Today, many of you I know I can see are on the Zoom call here on your phone or on your iPad. It's where I turn for all my news today. It's my primary camera, my video camera. It's where I pull up my books and my magazines. And oh, wait, that's not all, right? There's a whole other list that I have here. When I used to travel, remember those days on taking an airplane, it would be how I tracked my flights or called an Uber. Today, it's where I track my time and track my steps. It's my alarm clock in the morning. It's my voice recorder, my calculator. It's my primary GPS. And by the way, it can also make phone calls, right? Now, the reason I love this slide is because hopefully it is helping you to understand that these are no longer just little mobile phones that can play some games. These are fully functional computers, just like your desktop and just like your laptop. In fact, in some cases, because I visited many lawyer offices, these may be more powerful personal computers than might be sitting on your desk. I'm not the first one coming up with this idea. Walt Mossberg, he was the technology correspondent for the Wall Street Journal for many, many years, wrote about this a couple of years ago, that in 2017, which was the 10-year anniversary of the iPhone, that Apple launched this first iPhone. It's conquered the world, and it's not done. In fact, it has become the new personal computer for this day. If that is true, and it is, I like to think about the comments from Uncle Ben. With great power comes great responsibility. Now, I'm not going to take the time to go through these rest of these slides here because Stephen just did a fantastic job on going through the idea that the ABA looked at this. They tried to understand what are some of the aspects of technology that legal professionals are using today that may need to be incorporated into the model rules of professional conduct. And even trickle down into the state rules of professional conduct. In the past, lawyers communicated by phone, by person, by facsimile, or by letter. But today, we're using all of these mobile devices to do the same thing. And the summary that they came to, of course, was we have to make this duty of competence in the technology more explicit than already as it is implicit in the rules. And they came up with these this additional phrase in the comment that Stephen already did a great job of when it comes to the general duty of competence. Nothing changed in the rule. We all have this general duty of competence like we always have, which typically, by the way, it references CLE, right? Because in comment 8 to rule 1.1, how do we maintain competence? We do that by keeping abreast of the changes in the law and its practice, right? And we have typically always looked at that as a substantive duty. In other words, if you practice in real estate or family law, if something changes in those rules or new case opinions come up or whatever the case may be, then you have a duty to keep abreast of those changes in the substantive law. But the committee from the ABA added this little phrase that Stephen already talked about, including the benefits and risks associated with relevant technology. And as Stephen already pointed out, our good friend Bob Ambrogi, who writes the Law Sites blog, you can see back in March 2015, he started this blog post when it was just 13 states that adopted this, what he calls the duty of technology or competence. And over the years, he's had to amend this blog title because more and more states have now adopted it, and to where it's about 38 states that have now adopted this. And just like Stephen again talked about, you can go to almost any state, or all the neighboring states from West Virginia have all pretty much adopted that. Here in Ohio, we did so back in 2015. And when I go across the country talking about this, you can rest assured that West Virginia is well represented, because I always show the West Virginia rule for the exact reason that Stephen was talking about. You're one of the only states that changed the should to must. A lawyer must keep abreast of changes in the law, including the benefits and risks associated with technology. So what does that mean? In the last few minutes here, we're going to go into some of the specifics with mobile devices. Here's a great piece that I found on Bloomberg Law not too long ago, talking about what does technology competence mean. Now, he's got some really good bullet points down there, number 2 of which was, of course, e-discovery, which Stephen did a great job covering. But the first one is safeguarding client information. Again, Stephen covered 1.6, right? We all know that. Anybody that's watched TV for years knows that, of course, a lawyer has a duty to protect client information and can safeguard that. But the third bullet point I thought was good too, the technology that lawyers use to run their practice. That's communication, file share technology, software for document generation, calendaring, docketing tools, right? Today, the vast majority of us are using these tools based in the cloud, which, by the way, is perfectly appropriate. We can talk about that as a side piece in a little bit. I know Stephen addressed some of it. But using cloud-based technology is perfectly acceptable today. Not a problem with that, as long as you take reasonable steps to protect that information, which is the same duty you already have to protect information on your laptop, your mobile devices, in your briefcase with paper. So here we're just talking about technology competence and basically safeguarding client information, being savvy about the technology that you use every day. So let's just go through this. What are the benefits and risks associated with using mobile technology? Well, the benefits are perfectly known today, maybe even more so than ever before. The fact that you can really practice from anywhere, literally, right? Palm trees behind you. And today, that's even more so because the vast majority of you are practicing from home. I can tell because I can see your videos pop up every once in a while, right? The fact of the matter is, in the days, remember we used to go to Starbucks, but as long as you had your laptop and a phone, you pretty much could get access to anything you needed, as long as your files maybe were stored in the cloud or you had access, a good internet connection to do email. Not everybody was comfortable with it. I get that. But the point is that you could You could literally take your entire practice with you wherever you go. Those benefits are amazing. And in fact, today, more so than ever before, show us exactly what we can do. I cannot tell you how many law firms that I have spoken with that have repeatedly told me over the years that, yeah, we want everybody to come in. We prefer everybody coming inside. We prefer, nobody work from home. Now, I get that. There's many reasons why you want to have community and people involved in the water cooler and everything. I get that. But boy, I guess it just takes a pandemic, right? That it just really opens the eyes of everyone to really, truly understand the importance of using technology and utilizing technology so that you can practice everywhere. So what's the flip side of that? What are the risks involved with mobile technology? Well, there's two of the big obvious ones, right? The fact that it could be lost or stolen, even from a water park, for crying out loud. Again, the question is when it's going to happen, not if. In the days that we used to travel, right? I can't tell you how many firms tell me that they had a lawyer that left it in the back of a taxi cab. At one point, the iPhone theft in New York City was so incredible that the law enforcement used to call it apple picking, right? Because people would just grab iPhones off people talking in the street. And there's all kinds of things that can happen to your mobile devices. Steve and I, and probably Mike, and many of us that work in the technology side have heard all kinds of stories. I see this picture and I get a little concerned about it. I found this other piece of information from a company called Protect Your Bubble, which offers insurance for mobile phones. And one of their findings was that women are 42% more likely to have their phone stolen than men, except men apparently are 57% more likely to drop their phones down the toilet. So that's a little disconcerting. And I was very concerned about this until I found this story from CBS that apparently the same percentage would be willing to dive in and retrieve their phone. So I guess that's a good thing. The point is that what is the risks that are involved here, right? If we lose something, if the mobile device is stolen, if it's dropped and damaged somehow, well, the risk is we don't have to go any further than this, which is email, right? Email, which all of you on the call probably use today to communicate with your clients. If someone were to access your email today, would they not have complete and unfettered access to probably the most confidential and sensitive information that has been entrusted to you? And it's not just the communications, right? It's the attachments, it's the documents, because this is the primary way that we send and receive documents back and forth. And by the way, just as an aside, the vast majority of us use unencrypted email. Unencrypted email. It amazes me how many lawyers tell me that they would never use cloud because they would never use a cloud service because it's not secure enough. But then I ask them, do you use email? Do you encrypt your email? No, I wouldn't know how to do it. I don't even know how to do it. But these are messages that bounce around multiple servers on the internet all around, and they're completely unencrypted. Whereas the vast majority of cloud services are encrypted between your device and the service. So I'm no hacker, but if I was able to pick up one of your phones, I know what the email icon looks like on your phone. I can simply tap it. And again, would I now have complete access to so much information that I don't need to have access to? And again, the attachments, the documents, instead of snail mailing documents back and forth, we do it by attaching it to email messages. So what can we do in this situation? Well, I've got a few tips for you here. And again, feel free, Anita, if you need to jump in with anybody that has a question, send it to Anita, and I'll be happy to address it as we go through. First couple of things, I call them situational awareness. In other words, just being aware of some of the capacities involved with carrying a mobile device around with you. Now, first and foremost, just even having an understanding, an awareness that this is a personal computer that can also make phone calls and do so much. Just understanding the power that you have in your hand with this. It's not just a phone. This is a personal computer. But because of that, then, a couple of things to be aware of. How about public Wi-Fi? Although maybe not as important as it was a few months ago. But when you start to venture out and about again, and you either go to court and they have a Wi-Fi system there, or you're going to go sit in the Panera Bread or Starbucks or something like that, or maybe go to a client site, whatever the case may be. Just being aware of how your phone connects to public wireless. Again, the benefits of a public wireless network are fantastic, right? When I'm traveling across the country and I need to check email or reply to an email, or I need to access a document to reply to a client, I love the fact that I can go to a Starbucks or even sit in the parking lot of a Panera and connect to their free Wi-Fi and get my work done. That's an amazing benefit. But what are the risks involved with this? Well, here's a story that came out on the, I think on Medium called Matter, but it was a story posted online that, a lot of us kind of have this vision that when we talk about hackers, that it's somebody maybe sitting in a very dark corner of the coffee shop over there and they've got a hoodie on, right? And they're not talking to anybody. But that's not the case really today. In fact, anybody could probably download a little piece of software that basically just looks in the air for any kind of data packets that are being sent back and forth between somebody's computer or mobile device and the wireless hotspot. Does that make sense? In other words, when you go to Starbucks and you log on to their Wi-Fi network, they're not asking you for a password, right? If you go to somebody's client site, they don't typically ask for a password. That's an open wireless network. If they require a passcode or a password, that's great, because then that adds a level of security. But if you go to Panera, Starbucks, something similar, you just jump onto the Wi-Fi. Well, that means there's lots of other people on that Wi-Fi network. And there could be somebody sitting there, what we call packet sniffing little packets of data out of the air. Now, they may not be able to find an entire email address. It might be a portion of it or so, but there are some applications out there on kind of the dark web or the gray web, if you will, that you can download to kind of piece back together some of this data. Now, many lawyers tell me all the time, well, what I deal with isn't that important. There's not going to be anybody sniffing. That may be true. That may be perfectly true. There's probably not somebody out to get you necessarily in doing that. But the point is that you need to be aware of these risks on there. And one of the ways that you can mitigate this risk is know that you can, number one, go into your settings in at least your iPhone, and I know you can do this in Android phones as well, and you can say, forget this network, so that it doesn't automatically join that same network. You can see at the bottom on the settings here, you can say, ask to join networks. No networks will be joined automatically. So if you've connected to it once, it'll just connect to it automatically the next time that you're in there. And you may not want that. So you may need to go in and just uncheck that. Or maybe even better, consider using a VPN, a virtual private network. Now, I'm going to guess the vast majority of you on the call have heard about a VPN, because more and more I talk about this, more people have heard about it, but they just get in that mindset that, Stephen, you were talking about earlier, where they like, well, that sounds really techy, and I'm not that tech savvy. I'm not that computer literate. Boy, if I had a nickel for every time a lawyer told me those phrases, I would be very rich and sitting right there on that beach, probably not here. Like, you need to at least be aware that these are some of the risks. Now, there's lots of VPNs. There's NordVPN, ExpressVPN. I'm sure you've seen a bunch of them, but here is my quick recommendation. For somebody, if you've never used a VPN, you need to become competent about what it can do for you. Here is a great service called TunnelBear. I have no affiliation with it other than the fact that I find it so easy and simple to use. And for those of you that have never used a VPN or explored one, it's a great place to start. It's a cute, little bear. I mean, I know he's roaring right there, but if you go to tunnelbear.com, it will literally let you download an application for your Windows, your Mac, your iPad, your Android device. All of them are there. You don't even have to sign up for an account. You can do a free account, and it gives you about 500 megabytes per month, which is plenty to get your toes dipped into the water of understanding what a VPN can do. Tunnelbear.com, sign up for it. When you turn it on, the little bear literally digs in the ground and digs a tunnel for you. It's so cute. How can you not like it? But if nothing else, it at least gives you a good idea of what a VPN can do for you. I don't even use a VPN all the time. If I'm at a Starbucks and I just want to check Facebook real quick, I'm not going to turn the VPN on for that. But if I know that I'm going to send an email to somebody, I'll turn the VPN on. So just consider about when it would be important to use a VPN. Okay, number 2, situational awareness, GPS. All of you know that today, I don't even buy a car with GPS built in. That's a waste of money in my mind. Why? Because I got a far superior GPS right here on my phone, and I just put it into my car driving around. I use the benefits of GPS are fantastic. It lets me access maps. I love using Yelp when I go to when I used to go to different cities and I wanted to see where to eat. It allows me to check the weather exactly where I am. And of course, it allows my phone to be found through Find My iPhone. So the benefits of GPS are great, but what are the risks? Just something to be aware of. Basically, if you're using an iPhone today, because Apple uses these location services for a variety of different apps, which again have great benefits available with it, just know that if you go into your settings app, go to privacy, go to location services, go to system services, and go to significant locations, it will literally have a list of all of the places that you've been within the last few months. Now, that's not necessarily a risk, but it's something you should be aware of, right? With the GPS. I actually go into my, what they call them the restrictions under privacy. They call them restrictions there. And I add a restriction on my phone to say, don't allow any changes to be made to location services unless I have a separate passcode that I put in on there. So I show this to people and they get very terrified of this. I'm not really sure why, maybe because they don't want people to know where they've been, but you can see this was one of my travels I did about a year ago that I was going south from Cleveland and all the different locations where I was. Now, the other reason I bring this up is not necessarily because of a risk for you, even though this is how I introduced the slide, but just quickly from an e-discovery standpoint, we've actually used this data several times to substantiate somebody's story as to where they were at a certain date and time. Because I can't go to like AT&T or Verizon and get this kind of information. Typically, they just ignore, any kind of request, right? But I have this information right on somebody's iPhone. So just being aware of it from that aspect. And then lastly, situational awareness. Keep your apps and your operating system updated on your mobile devices. You ever see your app store and you have that little red icon on the top with numbers or under software update? That's just the phone telling you, hey, there's an update available. You should consider updating. You don't have to do it the day it comes out. A lot of people are telling me they're a little nervous about, updating immediately. That's fine, but don't wait too long. Because these updates typically have security refinements involved in them, or security patches, as we call it, to make sure that you're going to take advantage of all of the more secure components of the operating system. Okay, moving on from a situational awareness to passcodes. We love them. We hate them. Well, actually, I don't know anybody that loves them. Most people just hate them, right? In fact, to the point where Protect Your Bubble talk has shown that way over half of people that use an iPhone or an Android don't even bother putting a passcode on there. It's too much trouble. Now that's changed probably today because most of the companies require you to have a passcode on there. Like they don't even let you use the device until you put a passcode on there. Now, in the past, if you have an iPhone, you could put a 4-digit passcode on there. Although I think I've got a slide in just a moment that shows you Apple changed that to where now it requires a 6-digit passcode. Some of the Android devices had this. So instead of like having a tappable passcode, you could just put a little pattern on the screen, right? You could just trace a little pattern and it would unlock it for you. Now, I thought that was cute until somebody pointed out that you don't have to be a hacker to get into those phones. All you had to do is you just had to tilt the device just enough so that you could see the finger smudge of the pattern, and you just follow the finger smudge pattern, and voila, you're in. I'm no hacker, but just having an understanding that those are some of the risks that are involved with not having an adequate passcode. Now, when you put a passcode in your device, probably all of you have one by now, just make sure it's a good one, right? We see this story come out every single year, that iterates the worst passwords of that year. And you could probably guess, if I didn't even show you this list, you could probably guess what the top worst passwords are going to be. And if any of you have one of these on your phone, you don't have to raise your hand, just quietly make a change as soon as possible. Because the point is that people tell me, a lawyer say, well, no one's going to get into my phone. It's not going to be that big of a deal. But the thing is that you're probably using these passwords in multiple places, right? And so I think there was a story, it just came out last week, that they talk about they're online now. If you go to the dark corners of the web, you can download lists that have billions and billions and billions of login credentials. Not because people are trying to like search for somebody they're going after, but because you can put those email addresses and the passcodes together. And what you do is you have these tools that will go after what we call brute force attacks on websites, because there's a good chance that some of these passwords are going to work. And once they get access to an account, then of course, it's like what Steve showed just at his very beginning of his presentation. They could hold your data ransom, for example. Lots and lots of law firms that are sadly and tragically falling prey to these ransomware attacks. It's not really an attack, because what happens is it's just somebody, unfortunately, inside their law firm just clicked on a link that they should not have clicked on, either because they're ignorant about it or they're being negligent about it. But there's no room for that today. You have to know what you're clicking on today. 1 in every 142 passwords is 1, 2, 3, 4, 5, 6. That's deplorable. And again, for legal professionals, for all of you on the phone today, it is so critical and vital that you need to make sure you have those passwords. You're not immune from it today. Again, many law firms like, well, we're just a tiny firm. No one's going to care about this stuff. But you still have information that people do care about. And it's about ransomware. It's about taking out all of your data if you don't have a backup or something along those lines. Okay, here was the slide I just mentioned that a few years ago, Apple just realized 4 digits ain't enough. We're going to 6. Because it's much harder to crack or brute force that passcode. And by the way, I always make this point too. Is a passcode perfect? Is a passcode always going to protect your information? No, of course not. A passcode is not perfect. But the point is that the rules don't require you to be perfect. All of the language in Model Rule 1.6 and 1.3, all the stuff that Stephen went through, talk about reasonable efforts and reasonable precautions. The point is that if you don't have a passcode, you are being completely negligent at this point. So should you have a passcode? Absolutely. No question. Does it have to be absolutely perfect? No, but it better be pretty reasonable today. And it always comes at this, what I call the balance between security and convenience, right? because I have so many people that tell me, well, I can't remember a 6-digit passcode, or what if I forget? You could have a very, very perfectly secure 26-digit alphanumeric passcode with multiple symbols and capital letters and small letters and all this other kind of stuff that we have today. Would a 26 alphanumeric passcode be secure? Absolutely. Would it be very convenient? No. It would take you 5 minutes to type it in, right? A 4-digit passcode is very convenient, but it's not very secure. So you see, we're constantly trying to have this tug of war between the idea of security and convenience. Now, today we have Touch ID, at least on the most all phones. Android was actually first before Apple came up with it. And we've even gone from Touch ID now today to Face ID, to where it can just recognize your face and open up, and it's really quick. It's really fantastic the way that they have designed it, the little cameras that are in behind. Talking about the passcodes there. If you don't have a passcode, you don't get access to your email. I've seen many, many firms, most of them that are sizable enough at least to have like an IT professional in there that if you don't allow a passcode, you're not getting your email, right? You're not using it. And I think that's a good way to go about it. So the passcodes, the minimum of a reasonable effort is putting a passcode on your phone. Make sure that it is a good one. And just by the way, this is a related but a side thing, password management. Boy, I cannot talk about technology ethics and competence today without mentioning password managers. I'm not going to spend a lot of time on it, but happy to answer questions. Here are the two of the best that I recommend today. If you've never done a password manager, LastPass is probably a better one to start with. I think 1Password is superior. There's others like Dashlane and RoboForm and some of the others. But to me today, LastPass is probably the best place to start with if you've never done one before. If you want to hear a little bit more about how a lawyer uses 1Password, this is Jeff Richardson. Again, he's an appellate lawyer down in New Orleans. He runs the iPhoneJD.com blog. I had a chance to interview him on my podcast on my website, appsinlaw.com. So you can go there and listen to Jeff talk about using his 1Password on there. Okay, number 2. I'm going to get 2 more, I promise. Backup. Make sure you have the backups. Now, you've been preached at ad nauseum, I'm sure, about using backups for all of your information. But what about your mobile device? Well, if you have an iPhone at least, you have a free iCloud account. And part of that iCloud account allows you to back up information from your phone. Now, typically the way this is set up is every night when you plug your phone in to charge and it's locked with a passcode and connected to Wi-Fi, it will back up the phone for you. And the reason that that's important is because when your iPhone is lost, when it is stolen, when it is misplaced, and you have to maybe get a new iPhone, then you can restore that information from your iCloud backup onto your phone so that you can continue working as if nothing really happened at that point. Now, in addition to an iCloud backup, you can also do a manual local backup. Now, we don't do this much anymore, but you can still connect your iPhone or your iPad to your computer via that USB cable the same one that you use to charge it at night. And when you do, the iTunes software will pop up, at least on the Windows computer today. And you can see when the iTunes software comes up that you can create a manual backup within the iTunes. So basically that means that you've got a backup typically in the cloud, and now you also have a backup of your phone on your computer. You can never have enough backups. I don't do the manual backup every day. I maybe do it once or twice a week. But every night my phone is getting backed up to my iCloud account so that I have that confidence that that information is there and it is available. Another piece of software that I just reviewed on my Apps and Law website, if you wanted to go and check that out, is called iMazing. iMazing allows you to do full backups of your devices, as well as allows you to move files between your mobile devices and your computer. And if you wanted to see that in action, you can go to appsinlaw.com. This is my blog. And then not only did I do the video showing iMazing being used to make backups for your device, but this is probably one of the best ways that I have found that you can collect and preserve text messages from your iPhone. It has to be an iPhone. In fact, I just worked with another lawyer close to me here in Cleveland, where I went out to their client site and I used iMazing to collect text messages from the client's iPhone, because this was obviously evidence, right? This goes back to the e-discovery components, that was related information that we needed to collect and preserve. And iMazing is a good one for doing that. So backups, cloud-based and manual backups, allows you to restore your data when necessary. Okay, last thing I wanted to cover. I've already did this as the way I started out my hour. Find my iPhone or find my iPad. And today the service is just called Find My, because again, there are multiple things that you can connect with the iCloud account. And this is free. This is part of your iCloud, free iCloud account that you get when you buy a Mac or an iPhone or an iPad. You have access to a free iCloud account. And what's great about it is that once you create this iCloud account, then you can log on to any computer connected to the internet and go to iCloud.com and be able to access your information being stored there in iCloud. There's also, by the way, a Find My app. It looks just a little bit different than this today because they've expanded it out now. Instead of just Find My iPhone, it's a Find My, and then it allows you to find multiple devices. But you can download this free app onto your iPhone and your iPad so that you can access that in different places as well. Why is this great? Because when your phone is lost or stolen, you can then go to any computer connected to the internet, go to iCloud.com, log on, and you can see the last location of your iPhone or your iPad or your Apple Watch or your AirPods. It will tell you on a map where that device was last located. Then you can also maybe have it play a sound if you want to. This is one of my favorite stories. I was giving a presentation in downtown Manhattan, and like 3 days before I gave the presentation, the story came out that a poor lady was sitting in a handbag store. A thief came in, grabbed her iPhone, ran away. One of the police officers used his iPhone to log into the victim's account, and they were able to track the phone about 2 blocks over and about 8 blocks down. And they were walking around like, okay, well, the phone says it's right here. Where is it? And the police officer made the iPhone, the victim's iPhone, play a pinging sound. And they say right there that a gentleman's boot started beeping and pinging because he had the thief had stuffed it into his boot. But they were able to do that because of the Find My service. Or you can put the device into lost mode so that basically when it does connect or ping back to the internet, it basically locks everything down so that no one can get access to any of that information. You can put an activation lock on there as well separately. And then what I call the nuclear option here is that if you can see that your phone is in, Timbuktu somewhere, or it's just completely out of your reach and there's no way you're going to be getting that information back, then you just give the command to remote erase everything on that phone. Now, hopefully you've already done an iCloud backup, right? Because then once you erase everything on that phone, you can go get a new iPhone or a new iPad, and then you can restore all that information back onto your new device without missing a beat. Your clients won't even know. And you've basically done the remote erase on there. So the Find My iPhone, it's free. You already have access to it. Everybody knows that this exists. And one other quick tip that I do is perform an iPhone or Find My phone fire drill, right? I have multiple people that they're not doing the fire drill on purpose, but I tell people, go put the phone in the car, in the garage, and then come inside in the house and go to iCloud.com and see if it can find it, right? Put it outside somewhere. Like, just do it once or twice so that you have a good idea of how it works and what it looks like, so that you have a comfort level, a competency level of understanding how something like this works, so that when it really does happen, you have a comfort level with being able to find that information. So here's my quick takeaways. Consider using a VPN for open Wi-Fi networks. Just go to tunnelbear.com, sign up for a free account, and download those apps just so that you can understand how it works. It's very well integrated into your iPhone and your iPad. I just had a client that, well, several months ago, but she traveled to Argentina for, it was like some kind of a legal conference, but they were doing a wine tasting too. Anyway, she was very concerned about the fact she had her iPad there with all of her work, and she used TunnelBear to just turn it on so that when she was in the hotel or traveling around, that everything she did on the iPad was protected from the TunnelBear VPN. Keep your apps and OS updated. Always update them. If you can, put a passcode on your device. Make it a good one. Make sure you do a backup of all your devices, and then turn on that Find My iPhone. Perform a fire drill just so that you have a comfort level of how that works. Okay, Anita and Mike, I'm going to stop there to see if we have any questions, or Stephen or Mike, if you guys want to jump in with any other comments on there. I think we've got a few minutes before maybe we'll take another break here.
I don't have any questions, Brett. I mean, I have lots of questions, but I don't have any questions from our participants.
Okay.
You just scared the you-know-what out of most of us, I'm sure.
I think one of the comments that I would say is the most important thing that I saw that I use on a daily basis as an IT person is just the LastPass program, where you can download that onto your device, and you can do it on mobile devices, and you set up an account basically, and you go on any website that you go to or any kind of app you use on your phone or any device, and it will save that password. And then you have a master password that is like your ultimate long password if you ever want to make changes to those passwords. So I don't know any of the passwords to any of my things. I know most of them, but I can get into my vault. They call it a vault, the LastPass vault.
Right.
And all that is encrypting your passwords. Because, I don't know as legal professionals how many websites you would be going to on a daily basis, but I can imagine it would be a lot. And your staff, that's one of the most important things, I think.
I'm so glad you brought that up again, Mike, because again, I could speak for a whole hour on this, and I know Stephen could too. To me, this is one of the first things that I am honing in on today. In these last few months, I've been talking about this more than ever before. Like, we all have a little bit of extra time that we didn't have 3 or 4 months ago, right? If you've got 15, 20 minutes that you could apply to something on the technology side, let it be this. Because we all have multiple places where we are logging in. And what it really comes down to, Mike, because you know this, people ask you, is that we all have about 3 or 4 passwords we use, right? We have one throwaway password that we use for simple sites. We have a better password that maybe we use for something that we think is more important. And we got a really good password that we may use for our bank account, right? The problem is you're using those same passwords for multiple websites, depending on how you perceive as what's important or not. But I'm like you, Mike, and when I say this phrase, people cringe. I don't even know the passwords to most of the sites, the vast majority of websites, because I let 1Password and LastPass do that for me. But I don't need to know, and that's much, much more secure today than trying to remember 3 or 4 passwords that you use and kind of cycle around. You're never going to be as secure doing that than using a password manager. If you've got 15 minutes, this is where you should focus. Go ahead, Stephen.
I would also point out that these managers can be used not only for passwords, but all sorts of information like credit card numbers, social security numbers, and all those sorts of things that you want to protect, but you want to have access to. And I've seen it particularly useful, and not to be morbid about it, but all of us, something could happen to us, and our spouse might need access to lots of things. And you can use these tools to create the ability for people to obtain access or not, depending on what it is you're doing. So anything that you want to keep private to the world, but also be able to access for convenience purposes, like credit card numbers and those sorts of things, these are great tools for doing that.
Absolutely. I got so much more I could say on this, but Anita, I want to make sure that we take a break for everybody to go have a bathroom break or something.
We are going to do that, Brett. Thank you so much. For this time, we're going to take only a 5-minute break, and we will be back with Mike Mellace, and he is going to specifically address information you need to know about our database here at the West Virginia State Bar. So thank you again, Brett, and see everybody back here in about 5. Okay, I want to welcome everyone back. And before we put our last presenter on, I received a question immediately after I let Brett go. So I'm going to throw this out to all three of the presenters and let one of you pick up on it. Question is, I use Dashlane for my passwords. Is that okay? Brett, I'll throw it out to you first, unless you want to toss it to Mike or to Stephen.
I'll take it quickly. Dashlane is okay. Absolutely. In fact, any password manager that you are using is great. I mean, there are some that are a little bit older, like RoboForm, that's been around for many, many years. It works not quite as easily in the cloud because it was frankly created before we were all comfortable with the cloud. But Dashlane, LastPass, 1Password, there was one other one I was trying to think of today. I always just recommend, you know, because I try to keep things a little simple, like certainly for those that have never used a password manager, something like LastPass or 1Password. Now, the only other thing I would say is that at least on the Mac, and I think on Windows now, there are some built-in password managers. On the Mac, we call it the iCloud keychain. I just typically don't recommend that people use that, or I prefer using something over and above what you're going to find built into the operating system. Just, I guess it's a trust issue, that kind of a thing. But basically is any password manager you're using is way, way better than no password manager. So if you're using Dashlane, that's perfectly fine. It's gotten some excellent reviews on there as well. It's just, I typically say, if something is working for you, stay with it. If you've never used one and you are convinced now because we have browbeaten you the fact that you need to learn about it, then LastPass is a good place to start.
You know, I would just add to that, Dashlane is fine. But I would caution that if you decide to use a password manager other than the ones that we've talked about, and that would include Dashlane, ethically speaking, if you're going to keep client confidences on there, or the ability to access client confidences on there, you do have some duty to investigate the provider and make sure that they do provide the requisite security, that they do have a good reputation, that they do know what they're doing. You know, for example, I don't know, like TikTok, you know, which is not a password manager, but, you know, that would not be a good place to be storing important stuff, right? And you need to kind of look at that and make some assessment. But no, Dashlane and the others that Brett mentioned is fine. I use 1Password, but they're somewhat interchangeable.
Yeah, and just quickly, by the way, I'm sorry, Anita, Mike, I don't want to take
go
anything
ahead.
away from you, but I just quickly say, one of the reasons that we mentioned LastPass and 1Password, and I think even, obviously Dashlane will do this as well, is today, these are cloud-based tools, right? You have additional encryption that you can apply on these, but what is wonderful, and Mike alluded to this, is that I set it up on my Mac, but I can also access those passwords on my Windows computer, on my iPhone, on my iPad. In other words, I have access to this information wherever I am. Mike, you did a great job of mentioning that, is that if I go to a website, like my bank account, and I want to log on, I can do that from my phone, my Windows computer, my Mac computer. It synchronizes all of those changes. If I update a password because I changed it, right? Because they had a data breach of some kind, then if I change it, it then synchronizes that change of that password to all the different locations around. So that's one of the things that today you're going to get with any of these. These are more services than they are products, right? You can download the 1Password software or the LastPass software, but typically they are services that you're paying for. It's a subscription based typically, and then they are synchronizing across all the changes and information that you have, so you can access them from any device.
Just make sure that your master password to get into any of these password managers is a good one.
Yes.
1, 2, 3, 4 would not be a good one.
No.
All right, thank you, gentlemen. And what we're going to do now is we're going to take all the information that you have learned after we get off this presentation. I know everybody's going to be logging into LastPass or into 1Password, but before that, Mike Mellace is going to go over what we have available at the State Bar and basically how to use it. So turn over to our IT director, Mike Mellace now.
Absolutely. So today I just wanted to talk a little bit. They're more of a wide range of all technology topics, and I really like the mobile functionalities there that he was talking about. But I think that my focus on this was just going to be to give you some tips on how to work with the bar and technology and some of the things that we offer. So if I can get my slideshow to move here. Okay. So I just want to go through some of the online services because we do get a lot of people that have questions and maybe they don't realize some of the things that we offer. And you know, just some tips on a few things that we have on our membership portal. And then I'll go through some of our resources that we offer to all members that are helpful, some of them are kind of member benefits like Fastcase and some little things related to that. So I want to just walk you through our membership portal once. So we have a membership portal where you can go in and update all of your information, but there are certain things that you may not realize that you have access to make changes to. When you log inside of the membership portal, you have the ability to submit your CLE compliance information, update your membership profile, file ProHawk Vice cases. This is a test account that I use, so it has a lot of weird information on it. But this just kind of shows, let me go back up to the top. So this just shows where you can view or update your member information. It's pretty simple. We have a lot of people that have issues with changing their password all the time, and they forget them consistently. So, you know, that's why I wanted to emphasize at the end of that LastPass thing is a very helpful thing. And I even use it for this, for the membership portal as an administrator. But, you know, we have a membership profile where you can go in and update your information, where you can select your firm name and your some things like your the bar blast. If you select on this that you would like to receive the bar blast, then you will be on our list for our weekly newsletter that gets sent out to members every week. And it's really critical that you do, if you are practicing law, that you do receive the bar blast, because if there's anybody on here that does not get the bar blast and has any trouble getting that, then let me know and reach out to me. But there are a lot of people that consistently use that to contact or to see all the information we have going on.
And we strongly encourage everyone. The bar blast has information from our providers, from our court, updates. We really, really encourage everyone, even if you don't want to read it all the time, at least look through it. It's done in a format that you can scroll through it and in 3 or 4 words tell what the topic is about. If you're not interested, go to the next one and look at the 3 or 4 words that tell you about that one. But please don't not get the bar blast, because we get so many people and they will say, I didn't know that, I missed such and such. It's because they had unsubscribed from the bar blast. So we strongly discourage unsubscribing from that, even if you want to unsubscribe from our other Constant Contact account, which Mike will tell you about.
Yeah, so the receive advertising emails, we have an additional account that is a separate place that you would unsubscribe from, where you would not get emails from us if you wanted to stop getting emails from local CLEs. They different organizations will pay the bar to send out emails, and we will send those emails out on their behalf. And so that is what the advertising email section is here.
A number of our attorneys will use this for multiple reasons. If you are a West Virginia licensed attorney, we will send the emails out for you. All the returns are to you. It is 7 cents per attorney that you wish to send it to. Some of our sponsors or other vendors, anybody that is not licensed attorney can use it, but it's at 15 cents per email that it goes to. And to assure everyone, people who use the bar blast or this second account do not receive your email address. That's why it goes through the state bar. So your email address is very tightly protected by Mike and the state bar database.
Yeah. So the information that she was talking about with emails, we don't ever release those to anybody unless they are having a specific agreement with us. Like, you know, I think ODC has an agreement and the Supreme Court has an agreement with us to where they would be about the only people that would have access to our information. And on our website, I'll show you here in a few minutes where it shows that your information is protected. You have to actually log in for anybody to get access to your email address. The Lawyer Magazine, obviously, you can subscribe and unsubscribe from it here under this page. The Supreme Court notifications, we don't have the text message functionality working. It's still on here, but you can sign up for specific alerts by county here. Something that may be critical within the next few months, years, and we've had the court reach out to us, is the COVID notifications from county courthouses. Their communications people are working with us to let us know as soon as they know a COVID outbreak has happened. If that is the case, if there's a COVID outbreak in some local county courthouse, we will contact bar members within that county and contiguous counties. We do that for court closures right now for if they have the power's out or there's some snow or some problem, the reason why the courthouse would be closed. So to get on that list, you can go on here under the Supreme Court notifications to get your information and be subscribed by which counties you want the information from. We have a few other things. It's just like different languages that you may speak. And there's a mentorship program for students and for young lawyers. This young lawyers mentorship program is something that the young lawyers are trying to focus on, helping young lawyers be mentored by attorneys that have some experience and kind of help them get into the practice of law in West Virginia. Additionally, this lawyer referral service section down here, if you change your lawyer referral service selection to yes, and you select today's date, tomorrow you will get an email that says, welcome to the lawyer referral service, West Virginia Lawyer Referral Service. Click on this link and it will allow you to set up a profile and become a member on the lawyer referral service and get clients from there. So one big thing this is very simple, but I'll just go over that. Changing your password right here, you have the ability to change your password at any given time on this page here. One thing that we have made some changes with over the last few years is this under members and reporting and fees. Anita had asked me to go over this. It's kind of a routine thing that most people are used to, but if you're in a large firm, you may not see this. This reporting and fees section page is for attorneys to submit their financial responsibility disclosure and IOLTA information. If you are in a firm with 5 or more attorneys, you will not have to submit this. You will have a firm administrator that has been designated. Our membership bylaws were recently updated to reflect these changes, saying, it is in the bylaws now that if you have 5 or more attorneys, there is somebody at your firm can be responsible for this, for submitting the information. If you're a firm administrator, this drop-down menu of firms is where they would go to submit their information for the entire firm. And when they submit that information as a firm administrator, that information is applied to all of the members who have their employer listed as, let's say, the Supreme Court of Appeals. If you select Supreme Court of Appeals, you will then, as your employer, that you will then be put on their list for membership fees. And so when they go in, they get a giant invoice with everybody that works for the Supreme Court. So hopefully that's helpful information. On this form, you have to update every year your address of record. You can only have one address of record. At this given time, we give you the ability to select county information there. And we just encourage everybody to have that information updated on an annual basis. Something that we implemented within the last, since 2017, was this IOLTA information. We are now tracking online your IOLTA account information. So every year you will go to this and select whether you are exempt from the provisions of Administrative Rule 10. If you are, then you are typically like an outside, like an inside counsel. You're not actually practicing law, or you're maybe a government lawyer that's not necessarily representing anybody. So, but if you do select that you have an account at this point, every year your list of accounts will show up here. To create new IOLTA accounts, we have a box here that pops up where you can fill in your account information and report this information to us. The main thing that we implemented this in 2017 was that we wanted to be able to track your account, your IOLTA accounts, so that banks were able to communicate that information to us on a quarterly or monthly basis to make sure that client funds are not being used for the wrong purpose, or overdrawn accounts, or just that the IOLTA funds that are in that Rule 10 are being used as they're supposed to. So the banks are actually in control of closing the accounts. Whenever it closes on their end, they report that information to us.
2 points of clarification. One, before we leave IOLTA, this is a Supreme Court program that was in 2010 turned over to the West Virginia State Bar. So this information is mandatory that it be provided to the State Bar, but we manage this account basically for the Supreme Court of Appeals. I did receive a clarification, Mike, before you go any further on where you are. It refers to the text message portion of the court closure notification. You said it is not currently working. Is the email notification section currently working?
Yes. So we do have the email section up. We had planned on getting the text message service implemented, but we just, with all the COVID stuff, it just has not happened. Even though it has been on there on our list of priorities, we added it a little too soon and didn't get to it. So we would love to try to get that going soon. But the email portion, I think, will be important, and we'll see how the COVID stuff goes. But I was contacted a few weeks back saying that the communications director at the court would like to start relaying all that information to us, because time could be critical if we have a bunch of people that have went in a courthouse and been exposed. You know, we want to make sure everybody in those counties and contiguous counties are notified. You may see it on the local news or something before us, but I'm hoping that the court will relay it to us in a timely manner. So
one thing on the notifications from the court, we do not provide every lawyer in the state with every bit of information. What we try to do is we use the contiguous counties, so that if you are in Parkersburg, let's say, you're going to get Woodward, you may get Cabell may get some information. So we don't advise the Eastern Panhandle counties of something that maybe is going on in Wood County and vice versa, to keep the number of emails you receive down. So if you do receive one, it's well thought out on who we are sending it to give you the information you need without overburdening you with more emails than you already get.
yeah. And so the financial responsibility disclosure is basically the same thing. It asks if you're in the private practice of law and if you have insurance, and then you fill your insurance information in there, and it will autofill from your last year's insurance information. And if it's changed, you just need to make changes to it. The Rule 14 is a new rule that is in our new bylaws for succession planning. This year, we are tracking whether or not you are a sole practitioner or not, and we are going to track whether or not you have a successor designated or not. This information may be built out a little bit more next year. We are still waiting on the succession planning committee to finalize some changes with the court to see exactly what information they want us to track. But you may next year, you may have the ability to select a person from our membership database as your successor, and that person may then have to come in and select that they do want to be your successor. They may get a notification. So
Succession planning is mandatory now by court rule. Exactly what we are going to ask for, as the state bar has not yet been determined. As Mike indicated, we do not want to have too much of your personal information, but we do want to have enough information that if you are unable to practice for whatever the reason is, we can get your clients to the right person or the right people so that the practice can continue in some format. But the Office of Disciplinary Counsel has had for a number of years information on the website. You can either get it on our website or on their website, what they recommend by way of a succession plan. So if you are not looking into this now, you need to start looking into it because it is mandatory. If you have questions about the succession planning, your best bet is to contact the Office of Disciplinary Counsel. They can be more specific. I can help you with the generic questions about succession planning and Rule 14.
And so the rest of this form is basically the same stuff that was on the membership profile. Once you fill this page,
Mike is going to drive
but-
everybody. I'm asking him to slow down just a little bit. I apologize. He's going to try to not to scroll through quite so quickly.
So we have the ability to select your foreign languages here. If you do, this is helpful information that we will provide to people if they contact us and they say we need somebody who is fluent in sign language. We have a client that needs somebody with that ability, that is a lawyer, to help communicate with them. The French and Spanish and then the other languages have been very helpful to some people. But the school mentor program is a program that we are working closely with the Department of Education in past years, and the teachers will go on here and find somebody who has said they would like to be a mentor and contact them, and I believe they are doing some mentoring at schools. I believe I already explained the Young Lawyers Mentor Program and this information here. So let me see, move on to the next information here. So submitting your CLE information. Obviously, this is a CLE that you are on right now. And this is a transcript that I have for this account that I have. It's a test account. I'm looking at a transcript right now. You have the ability to download your transcript into a PDF format here and print that. And one thing that I will show you is after this seminar, you will receive an email that says you need to confirm your CLE credits. I have that in my slide deck here. This is what the email looks like for submitting your CLE credit. When you get an email, it'll have our logo at the top with your name and your bar ID number. If you get one that doesn't have your bar ID number, then it's not legitimate. We have not had, knock on wood, any kind of issues with this so far. There's a link here where you can click to confirm your CLE credits or to delete your CLE credits. Essentially, how we set this up a few years ago was that we decided it would be easier for attorneys to confirm that they went to a seminar rather than have to go in and find it themselves and then submit the information on their own. So we require all CLE providers to submit credits inside of the membership portal. And once they submit the credit for you in the membership portal, you will receive an email that looks like this with your name and bar number, and you will click on this link. And when you get to this link, you will see something like this page where it will tell you confirmation of CLE credit submitted by provider. And this will be a course that you have attended, and it will say that you need to confirm that the date is correct, the attendance hours are correct, and select from your reporting period that you would like to choose from there.
And this is really very important for right now. We are in 2 different reporting periods because the commission went to the court with a request. The 18 to 20 reporting period is still open until September 30. After September 30, it will close and you will be delinquent. But from now until then, you may report for 18-20. You may also, effective July 1, report for 20 to 22. So with this seminar today, when you get the information, please make sure that you check the correct reporting period where you want this to be applied. It will not automatically go into the 18-20 if you are still not up to snuff on your hours, so be sure that you select that one. And again, you don't want it to go on to 18-20 if you have already completed that. Make sure that you select to go on to the 2020 to 2022 reporting period, and that will be for any seminar or webinar you attend between now and the first day of October.
And so this form is just to add it. Once you submit this at the bottom, this button, this confirm attendance credit, it will then be applied to your CLE transcript. There's also a click here to delete this course from your transcript link there too. So if you already have this on your transcript, providers are given 30 days to submit your CLE credit for you. If you go an hour after your seminar and submit the course, you will be allowed to do that. But when you get to this, when you get this email notification, you'll still get the email notification saying that that you, well, actually no, you will not get the email confirmation because it will already see that you have it on your transcript. So so whether you submit it yourself or whether the provider submits it for you, you only get an email if it's not on your transcript. So you know, this is from your transcript. You are able to delete your information here and view your transcript. Let's see, one second here. There's somebody. If you can microphone X through it. Okay. So the information that we have here for submitting your CLE credit, you can go to submit your CLE credit, you go to CLE and submit credit. You choose your reporting period, and then you choose whether your course is approved or not approved. If you select an approved course and it is a WV State Bar course, you can search for the State Bar. When you click on the West Virginia State Bar, you will then be taken to where you can add this course to your CLE transcripts. So you can find the one for today and you can add your course as we're sitting here and adjust the hours. If you leave right now, then you might have to shave a couple credits, a couple percentages of credits off of your record here. But once you submit that, if a course has been approved in West Virginia, you're able to apply that to your record. So that kind of covers the CLE portion of a few things that we wanted to show you. If anybody is familiar with the ProHawk VJ process that we have on our website, we have everything has been converted from a paper process to now an online process. A few years ago, the court issued that we needed to start collecting annual fees for attorneys that are practicing law for more than a year in West Virginia. So if you are not a member of the bar, but you want to practice law in the state and you are going to do it for more than a year, you will pay an annual fee. So we have you have the ability to go in here and search for cases and make sure that your person that that has been pro-hawked in is correctly been pro-hawked in. If the submission status is listed as confirmed, then you are then they have been admitted, or they have been accepted by the submission has been accepted by us. We do not we're not the one who, what's the word for it?
The state
We don't
bar does
authorize.
not approve or disapprove your motion for admission. That is done by the presiding judge, but we are the keeper of the information. I know that some state court judges will check this. The federal court judges, especially in the Southern District, are very, very conscientious about checking this. So one thing that we do is we make sure that the attorney who is the local counsel does in fact have a West Virginia address. You cannot be a local counsel unless you have your principal place of business in West Virginia. One thing that I like to caution the people who are local counsel is if your national counsel or your pro-hoc counsel does not properly do what he or she is supposed to, or if they bail close to trial time, you are fully and completely responsible. You're not just there to help them. You are them. You are the representative of that client, and you may actually have to try the case. That has happened on a number of occasions where the judge says, no, I'm not going to continue this because the pro-hoc counsel stepped out. We are going to court. So that is something that we notify the local counsel, that you are responsible just as much as the pro-hoc-in counsel is.
And so to add a pro-hoc VJ case, you simply submit this this page here for the case information and the attachment of the statement of visiting attorney and verified statement of the motion, or the one-page standard form that is in federal or state court. When you get to the second step, it will ask you who the visiting or who the local attorney is. The third step will ask you who the out-of-state lawyer is, and then you can make a payment. And then at that point, it will be confirmed by us, and your person will be pro-hocked in. We still have people that send us paper forms, and they send them in the mail, and they think we're going to approve them, and we will send them right back to you. So, and with a letter that says do it online. So you do have the ability to go in and look at an attorney who has been able to practice law in West Virginia. So if you go to this pro-hoc VJ and out-of-state lawyer directory search, you can go and find an attorney that has been pro-hocked, been admitted by pro-hoc VJ, and you can look at the list of related pro-hoc VJ cases. That one doesn't have one, but this person has a case that was submitted in 427, and you can go in here and look at the information related to the case, and that will get you the ability to see that what cases they've been put in here for. You can also go, if you go to the pro-hoc VJ admission case list, you can go and look at the people who have been terminated, and that would kind of help you. Terminated means that the person has not paid their annual fee. And so there is a big list of people who have not paid their annual fee and have not submitted this information to us, saying that the case is closed. And so the ones that are listed in here and it's confirmed, these people have not paid their annual fees, and they're on a bad list. So that's one way to explain it. So I went over the CLE confirmation information. So we can move on to West Virginia e-file. The West Virginia State Bar membership portal is our database, and we have a number of people who use e-filing. E-filing is starting to be a very large initiative. I think they're maybe in 20 counties now. They're in a very large number of counties right now. And so they're trying to continue to roll out. It's not a very easy time to be rolling out to more counties right now. But if you want to start e-filing with the courts, you will have to go to the court's website and go to their West Virginia e-file section. When you do a registration and select a new account registration, you can select attorney, enter your bar ID number, date of birth, and it will validate that information with the state bar. So it's going to look at the state bar membership database to see if you are an active attorney. If you are not, if you're suspended, your access will be revoked to the West Virginia e-filing account until you are back on active status. Pro hoc vice attorneys also have the ability to use e-filing. And so the information that is pulled every night from our membership database is your membership status, your email address, your physical address, but you do have the ability to change your email address inside of the e-filing system. If you go in and make the change, it will not copy over that every night. But when you change the address information, it is the same information being pulled from the membership database to the West Virginia e-filing system. So the court came to us and said they really don't have a good list of lawyers. We want to use your database. And that was before I even existed. And then we created a new membership database. And so now they're able to look at our database and say, who are the people that are actually active lawyers? And so you can set up your account through their website there.
This is very important. At all the regional meetings, I reiterate this. The Supreme Court and the circuit courts that do e-filing use the state bar's database. If you change anything in connection with your addresses, email addresses, mailing addresses, phone numbers, fax numbers, anything, it is mandatory per the rules that you update the state bar within 10 days, but it's also essential for you in order to get the filings, because if it is not updated and e-filing is being used to get notices to you, you will not get them.
Yes, and so it's important to just update that information as much as possible, and realizing that when you change some of that information in the membership database, it will also change on your e-filing account. The court wanted us to have one good record, and so a lot of times just having the state bar and the court is a much better way to have both places the same, because like during the COVID crisis over the last few months, we found that a lot of attorneys are switching firms or moving around, and so it's very hard to, people are going and updating their information in our database, but they would not think to go to the Supreme Court and update their information there. So so this is a big thing that I think is very helpful to you. Some people get upset because they want to have different addresses, different places, but it's the best case scenario for the bar and the court. Okay. One thing that I wanted to go over that a lot of people don't realize we have is access to Fastcase. So I'm not going to go into the everything with Fastcase. I just want to show you the ability to use the two different types of Fastcase. So I am by no means a Fastcase aficionado, but I do know that you can go in here and search different jurisdictions and advanced case law searches. What you may not know, and this is just the part I wanted to show you, is that there is a Fastcase 6 and a Fastcase 7. Up here in the top right-hand corner of your screen, you have the option to go to Fastcase 7. Fastcase 7 will blow you away compared to the other one. This has a much more fine-tuned selection of states and federal versus state law. And it really, there's a lot of good information that you can go in here and you can save searches and different things inside of that. But through your state bar membership, you get access to this. So when you go to the state bar membership portal and you sign in, you just click on Fast Case here and it will sign you into your session. It will remember you every time that you go in here. But if you, that little toggle button will toggle you between the two different Fast Cases. I would encourage everybody to try out Fast Case. If you have more questions on Fast Case, you can go into fastcase.com/support, and they have webinars and trainings. You can call them. They'll walk you through and help you use Fast Case for multiple different things. Another thing that we have implemented that is kind of IT related is the State Bar ID card. If you go to our website, to the membership portal, sorry, I'm moving around here a little bit, but I wanted to show you. If you go into the members drop-down menu, you can go to State Bar Photo ID card. This will take you to a place where if you have the ability to request one, it will give you a link here to go request a bar ID card. Then it will take you to the DMV site where they have validated whether you are an active or inactive member so that you can get a card. If you have a West Virginia driver's license and have taken a picture within the last 5 years or something, I believe it's the last few years, it will tell you whether or not it can email or it can physically mail you a card with your driver's license photo on it. If you don't have a West Virginia driver's license, you just pick no, and this will ask for your information. It will give you a form that you can take to the DMV office and get a pretty little state bar card like this. That's actually the West Virginia driver's license. It looks similar. It has your picture on it. It has the state bar seal on it, and it has your bar number, date of admission, and all of that information. One thing,
yeah, it does not, I want to make it very clear, the state bar does not have and will not have your social security number. That is something done through DMV. The state bar does not maintain anyone's social security number.
yeah, we don't have that anywhere. We got rid of that a long time ago. So, but the DMV, it was they have a system that it was critical for them to be able to run it. They had to have that in their system. Once it hits their system, it goes immediately away. I believe it's just basically looking for your picture by social security card number. So one section that we have on our main membership website is the cyber threat section. We have under the for attorneys section, you can go and find out some recent cyber threats that we have identified. We have, from time to time, we'll have people that will tell us that they've been getting a lot of emails regarding some kind of phishing scam where people are trying to target attorneys. We've had in the past where people were trying to impersonate the state bar president. And when you go to their to the actual email, it will say Monica Haddad, but then if you look at the email address, it actually says like president101@gmail.com. So it's one thing that that our other speakers here talked today about is email scams and email problems and phishing emails. It's always important to, when you look at an email, look at the actual email address that it says it's coming through to. If you use Outlook or a service like that, you can click on the email address and it will tell you the physical address of it being, kca@wvbar.org, or if it's Anita Casey President fake account @gmail.com. This is just kind of a list of all the cyber threats that we've received from West Virginia licensed attorneys.
Hey, Mike, I just wanted to jump in. That's a fantastic tip to tell people that they need to look at that sending email address. And another quick tip, you may have it on this website when they go down there, is I always tell people to not click on a link unless you can, if you have any kind of an idea or you have any kind of a curiosity that it could be going to a different place. Like if it gives you a moment's pause, like this doesn't really look correct. One of the things you can do is hover your mouse over a link, right? So in other words, you can see where is that link going. Like one of the ways that I see this all the time, and you may have one in here, we get documents from something like DocuSign, right? So you get an email from maybe a client or somebody that it came from DocuSign and they say, you need to sign these documents. Now there's a button that says sign documents here and you click that button and it takes you to a website, right? But if you hover your mouse over that button, don't click it, but if you hover your mouse there, it will show you where the link is going. And many times you'll see it's not going to DocuSign.com. It's going to be like some kind of a weird looking odd email. Now here you're in a website, so it's not the same, but I'm talking about like if you're in Outlook or something and you have that link. Just to me, this is why we have issues with what we call phishing scams, or even today, what Stephen talked about earlier with ransomware. People click links that they should not click. And if you have even a millisecond of a pause on it, like this doesn't quite sound right, don't click it. Either pick up the phone and call somebody, don't reply to the email, but you can hover your mouse over a link in your email to see where that link is going to go to before you click it. Because that way you could save a lot of heartache and headaches.
And if you have questions, Mike is extraordinarily busy, as you might guess, but you can forward the email to him. It may not, I mean, I can pretty much assure you, you're not going to get an answer that day, but as he gets literally hundreds of emails every day, as soon as he gets an opportunity, he can let you know. If we get 3 of the same scam or 3 of the same email, then Mike will post it on the website. So the first thing would be to check the website to see, or excuse me, our website to see if it's already posted there, to see if it is a threat. And if it's not there, the next thing would be, if you don't have a tech person who you can go to, you may want to send it to Mike or follow the suggestions that you just got. Before we go any further, I have 2 questions that came in. One with the State Bar ID card. If you did not get the card, you probably should check with DMV. We merely are a conduit. They are the ones who produce the card. They can go into our system to see if you really are a lawyer, but I would check with them to see what may have happened to it if you did not receive it. The next thing, and I think I know the answer, but I'm going to pitch it to Mike because I know he knows the answer. Can someone get to Fastcase without going through the State Bar website? Mike?
Yes, you can, but I believe that it is, I believe that you have to pay for it. I think the membership, each member gets 1 account to try to access to. I mean, you can, if you are okay with your secretary having access to your membership portal login, then you can use it that way. But we don't have anything else for them to, like free accounts you can give out to your staff. But I will say that Fastcase has a mobile app for the iPad, and it is a totally free app. And a lot of people don't realize that, but their mobile app actually is free for anybody to download. You don't have to sign in at all. You, or I think if you do have to sign in, it never asks you to pay for anything. Because that was something I spoke with them about, because somebody was concerned about not having mobile access to it, and they thought it was going to make them pay for the Fastcase mobile app. It actually is a free mobile app that you can use. You can have your staff use the Fastcase mobile app for free, no matter what. Create a free account, and you have access to all the stuff that you would on the website. So one thing I was just going to throw out there, we don't have a whole lot of time. We do provide, and we have over the last few months, allowed access for any State Bar member to use our Zoom account. We have some Zoom accounts here that we utilize every day. You're using it right now for, we've had people do administrative hearings, depositions, mediations. If you guys have any questions about any of these things, I'm pretty good with that, or I can point you in the direction of another attorney that would be happy to help you, help talk to you about it. Because I know a lot of attorneys that have done these recently. This is a picture of our Women in the Law committee. We had quite a few people on that committee. Everybody has really worked well with technology over the past few months to kind of jump on the bandwagon with video conferencing. So if you guys have any questions about using our services and want to book our Zoom room for any time, you just call here to the State Bar and speak with Kathy Henning, the receptionist here, and she will take care of booking a Zoom conference room for you, and she'll let me know, and I'll work with you to set that up for you. And that's free for anybody.
And let me suggest one thing. Have a couple of dates that will work, because people are starting to use it more and more. Even though we have 2 Zoom capacities, we are starting to have conflicts with more people wanting the same date and time. So get a backup date before you contact Kathy. If the first one's not available, then we can do the second one for you.
And it's one thing that I think is good about it is that we can, an administrative law judge that approached me and said, I don't know how to use Zoom for administrative hearings, but I want to do it. And can you help me try it out? We'll do one hearing and make sure that it works. And unfortunately, I don't think she had Office 365 access, but in most cases, all of the courts are saying, do not use Zoom, use Skype, Skype for Business. Now, we believe that Zoom does not have any issues right now. They've covered up all their problems as quickly as possible as they've came through. They didn't expect to have 100 million people using it all at once through the COVID stuff, but I think that they've done a good job of working with people. But I was just going to show you this, like the growth during COVID and this year. It's been, a lot of people are really using Facebook Messenger and FaceTime, but Zoom and Skype are the biggest, and Google Duo and Microsoft Teams. I don't know if this is some statistics that I found on Business Insider. I couldn't imagine a lot of people were using FaceTime for that, but for business related things, but I guess so. We also have a mobile app on our website that you can look into, and you can access all the stuff that you can on our website, like our news feed, our magazines, our directory, membership information, fast case. Kind of ran out of time. I was going to go through that. One thing I would like to mention before I wrap up, if you are if you don't have all your CLE credit hours, please go to our website and click on this giant green button. We have 28.5 free CLE credit hours, and that is, all these are online, but you can do all of your CLE credit online at this point. So you can do all 24 hours. We have anything from court, COVID seminars with the judges, to an ethics award seminar, to keeping yourself healthy in the pandemic, intellectual property, landlord tenant. So these are all really good things. And even if you, I believe you can use these for this new reporting period, if you wanted to go ahead and try and get your 12 hours of online credit for this next reporting period. These are all very good seminars. So I think that pretty much covers everything that I was going to talk about today. You will get an email asking you to confirm the CLE credit hours after this. It probably will be in the morning, since it's almost 5 o'clock. Well, it'll be almost 5 o'clock by the time I get done with this. So just please go in and confirm your CLE credit hours tomorrow when I get those in there for you. And I'll turn it over. Anita, do you have anything else?
Only a wrap up. If you have questions on anything that Mike has talked about, you can contact him probably best by email. But somebody here knows how to work everything. We don't all know how to work everything, but we can get some information to you on anything that you saw that he has talked about. I want to again thank Steve and Brett and Mike for taking the time to do this. Technology is awesome. It's also scary. We can't live without it, but sometimes we have a little trouble living with it. This is going to be the end of the presentation today. The courses that we are offering for CLE credit, the webinars, are planned for and presented for the purpose of CLE credit in West Virginia. So as Mike has said, you're going to get an email. You can put it on your transcript here. Unfortunately, we do not have the finances, nor do we have the sufficient number of staff to report for you or to pay for anything in another state. There should be all the information that you need by way of materials and CVs of our presenters. But if you need to report in another state, we're going to unfortunately have to tell you you'll have to take care of that yourself. We have our next webinar. Well, we have some that will be coming up. Watch the Bar Blast on the social justice issues. That one will be on July 30. And then we have another webinar that is going to be on consumer protection issues on September 16. So again, gentlemen, thank all of you for your presentations and the great knowledge. And we are going to sign off.
Thank you.
All righty. Thank you, guys.